Hello, ladies and gentlemen. I'm Robert with Knowmium, and this is an edition of Business Casual where we talk to business people and professionals around the world, especially now that we're doing so much virtually. Today, we're joined all the way from Anchorage, Alaska by Chris Yandel. Chris, you know yourself a lot better than I know you, so I'll let you do your own introduction.
Sure. So my name is Chris Yandel, and I am an assistant attorney general who works in the Alaska Department of Law here in Anchorage. As a brief background, I actually met Bob when I was an English teacher, and we were both working in Seoul, and I was an English teacher in South Korea, Russia, China, Saudi Arabia, and Malaysia. And I, after 7 years of teaching, decided to change careers, and I went to law school at the University of California, Berkeley. After law school, I started my legal career as a law clerk here in Anchorage for a now retired judge. And then I went to work at a civil rights firm back in California for a few years before I accepted my current position, which I've been at for a year now.
Excellent. That's a nice long bio condensed into very quick words. Awesome. And so as a lawyer working for the state of Alaska, what could you describe a little bit about what do you do, but in terms of what would the general global business audience maybe want to know or need to know about your work?
Sure. So I am effectively the state of Alaska's defense attorney. So if someone or some company sues the state of Alaska, most often in my line of work, it's been sort of people who are injured by, a police officer or in prison, and they decide to sue the state of Alaska. I am the state of Alaska's defense attorney. And so I don't often deal with lawsuits involving the private sector anymore, at least in this position. I think the sort of most useful takeaway as a tort litigator that I think would help business people is to understand sort of the risk analysis that just any sort of litigator makes, really. And so from the tort side, like what we always are looking at is we want you to be acting reasonably before you get into court. And so that means you need to look at like how much would it cost to increase safety versus like what is the risk, right? So how likely is an accident? How bad is an accident going to be? And then compare those two numbers with, how much is going to cost to increase safety. And then, and if that's your heuristic for making business decisions, I think you'd be helping your lawyers a lot on the back end when you get in trouble. And they would appreciate that.
Interesting. So possibly saving some money in the long run by making good decisions now.
Yeah, litigation is super expensive. When I was in the private sector, my billing rate was like $400 an hour, and I was like the least senior attorney in my firm. And if you get into litigation, that's hundreds of hours of discovery and motion practice and hearings, and and you're going to be paying the partner in charge of the case $1,000 an hour. And so like, if you can, understand the kind of the risk analysis model that drives attorneys' decision making, both to bring and how they defend lawsuits, you can sort of decrease the risk you'll find yourself in a lawsuit, and then you can also decrease your costs by giving your attorney a really strong case where they're not gonna they'll be able to dispose of the case at a much earlier date with fewer legal fees, and also likely for a much lower settlement amount.
Excellent.
So
I'm sure there's a ton of different business scenarios that we could apply that to. We're not going to do that right now. It's like, let's talk about a bank. What can it no. So what do you find, I guess, most challenging or something challenging about your work, and how do you get over any of those obstacles?
Sure. Well, I think there's two discrete issues that have been particularly challenging in my current position. And one is, the first is, often I am dealing with a party who's been injured sort of by it through some interaction with a state employee. So let's say I have one case where a woman slipped and fell at the Anchorage airport, and so she's, she injured herself, and now she's suing the state of Alaska, saying that we should have maintained our airport in a more safe condition. Or, I have another case where state troopers were conducting a high-speed pursuit, and the person they were pursuing lost control of his car and hit some civilian vehicles, and now those civilians are suing us. And so these are a lot of my cases involve injuries, which then necessitates a lot of medical records. And I am a lawyer and not a doctor, and so I've had to sort of learn how to read medical records. And so for the first 6 months I was doing my job, I just, I had Google up all the time and was constantly Googling medical terms to figure out what the heck I was reading in these medical records. And so that's been one issue, as just sort of my knowledge. A second issue is about, it fluctuates, but between 25 and 33% of my workload are what attorneys call 1983 cases, which are civil rights cases where you are alleging that some state actor has violated one of your constitutional rights. And the vast majority of these cases are brought pro se, which is lawyer speak for without an attorney, you're representing yourself. And they're also brought by prison inmates representing themselves, usually alleging that some prison, correctional officer or medical officer violated a constitutional right. Because of the way the American legal system is structured, it's very easy to bring these lawsuits and for them to kind of survive the initial sort of filter, and that means we get into discovery. And in my experience is the vast majority of these cases are resolved on motion practice after discovery is completed. So that kind of before we would go to trial, I will file a motion saying, look, as a matter of law, we win. We have all the evidence now. There's no set of facts that shows there's any legal liability on the state's part. But they're even though that's about 25 to 33% of my caseload, they represent about sometimes half the work I do, because it's just much harder to be a lawyer when the other party is not a lawyer themselves, because it's just like, as a discrete example, one of the first things that happens in a case is the judge will send both the parties a thing saying, talk to each other, figure out a schedule, give me your proposed schedule. And when you're with another attorney, it's like a 10-minute phone call. You knock it out. It's super routine. I was dealing with this guy in prison. It took me 6 hours of phone calls over 2 weeks to create this schedule that with another attorney would take 10 minutes. And, and then when you're reading anything that they submit to the court, you're trying, it's like reading a foreign language, because like they're not lawyers and they don't know the law. And so they're just kind of like throwing spitballs at the wall and seeing what sticks. And you're trying to kind of weed through what's often handwritten and bad handwriting with tons of spelling errors, and trying to see, like, can I craft a cogent legal argument from this kind of nonsense that I'm reading? And it's just a very different challenge than when you're sort of litigating against a more sophisticated party who's represented by another attorney.
Interesting. One thought that when you were saying that it's really easy to bring these lawsuits, it reminded me of I don't remember the guy's name, but it was somebody who the Guinness Book of World Records had nominated as the world's most litigious person in the world. And then he turned around and sued Guinness, just adding one more lawsuit to his world record.
Yeah, well, I suspect that wouldn't go very far. It's sort of interesting because there is a filtering mechanism at the very start of litigation. And in general, it's not a very strict filter, but it's relaxed even further for prison inmates who are representing themselves, just because of the constitutional issues that it raises. And so the courts are just generally very felicitous to them and sort of bend over backwards to try and do their work for them as much as a judge ethically can.
Interesting. Do you ever have, if you're defending the state,
yeah,
how often do either you or I guess the state as a whole say, I think, legally we will win, but maybe ethically we shouldn't? Does that ever happen? I'm not asking you to discuss any specifics, but
I have never had a case yet where I have sort of I mean, I guess you wouldn't, right? Despite sort of the jokes and sort of some very, high profile bad actors, my experience has been most lawyers take their ethical obligations very seriously. And so, I mean, because you risk losing your license, right, to practice law. And so, um, uh, and so generally, I have never come across an instance where I even like had the idea. I was like, oh, I can do this unethical thing to win the case. Usually, if your case is that bad, uh, you're just trying to minimize the settlement payment that you're gonna, so in that case, if it's like, oh, this is a loser, like the car crash case I mentioned, like there's almost no world where I see a jury not giving these people money. Like I can't imagine us ever winning at trial. Um, and so then it shifts your strategy. Instead of like thinking of what are some like maybe underhanded ways I can win the liability side of this case, it's okay, what can I do to minimize the state's risk, right? Like my client has exposure here, and now I have to, I know we're going to pay out a bunch of money. It's now my job is just to find arguments I can make, that will minimize the amount of money that I know we're going to end up paying. And so then that sort of, it just, because it's not, despite like the adversarial nature of the US legal system, it's really more about like risk analysis, and then it is like a binary winner or loser, because like 97% of cases settle. Guaranteed winners are going to settle, guaranteed losers are going to settle, and everything but like the 3% of like the most closely contested cases are going to settle. So even if I'm like, oh, I have a 75% chance of winning this case, well, going to trial is very expensive. I'm going to pay an expert witness $500 an hour, to sit on the stand and testify. If it's a doctor, $1,000 an hour to sit on the stand and testify. And it's like, I can say, if I can settle this case for, $25,000-$50,000 instead of spending that $50,000 on trial and legal fees, and settle it 3 months before trial, then like that's good. That's good for the state's pocketbook. And so,
Mhm. What I
that's
was
like really the more way we as lawyers think about it than it's not like I'm trying to win the case. It's I'm trying to like do what's best for my client financially.
That makes sense. I've thought about, are there like super old laws from, that come up and they're like, well, according to this law of 1860, technically this person might be, guilty, or they would be the victor, but I don't know if we should really pull that out of the 1860s law book.
I think the only times I've ever had to reference like 19th century law is when it's almost always a self-represented party is making some kind of completely crazy argument, and it's almost always a very procedural argument. It's never like, uh, here is this crime that's on the books from like the 19th century. Let's try and enforce it now. It's usually more like, look, you're saying this crazy thing, and it's so crazy that we resolved this legal question like 150 years ago. Here's this 19th century case that lays out this bedrock principle of law that usually has to do with kind of the fairness of the legal system. And that's when you're like, I point to it and I'm like, look, the thing you're arguing is so crazy that 150 years ago, we recognized it would be bad legal policy to have that. And so look, there was this like, case from 1840 that already answered the question you're trying to bring up again. And so that's
Nice.
really the more common example of when you kind of quote to ancient law.
Interesting. All right, I've got one more oddball question
Sure.
because I'm generally curious. With so much wilderness, so many animals that live up there in Alaska, does the state ever get lawsuits because of something wilderness related? Like there was a moose, and the moose kicked my car, and the government should have had signs up about these meese.
Moose is the plural of moose.
Yeah, I know.
I have not seen that. No, I think the more common way I've seen sort of the nature side of Alaska come into lawsuits is that subsistence farming and fishing are quite common here in Alaska, and so it is a fairly unique category of damages that you have to deal with when you're litigating in Alaska and defending the state against state citizens. And so, and again, multiple cases I've had someone saying, well, I injured myself and that injury prevented me from hunting moose and fishing for salmon during the summer the way I traditionally did. And, and then I don't hunt for fun. I'm using it to actually like, I hunt them, I kill the moose, I skin the moose, and I, package it into steaks that I then eat for the rest of the year. And, I go halibut fishing, and a halibut is they're like 100-pound fish. They're giant fish. Like, so 1 or 2 halibut isn't, it could be enough food for months. And so they were saying like, oh, I didn't get to go salmon fishing. And that's 30 pounds of food that I didn't get, and that I had to end up buying from the grocery store that I would have otherwise. So that's kind of the most common way I see, Alaskan nature making its way into law here. I don't often see people being like, a bear attacked me at a state park. The state should have done more to protect me. And it's a sort of it's a very weird Alaskan who would admit, like, because we all know that you bring your bear spray when you go on a hike, and you don't go near the moose. And so,
well, it wouldn't be an Alaskan. It would be someone, it would be some city slicker, some guy from Los Angeles.
Yeah. So I think there's like pretty good signage at all the state parks that I've been to. So, and then I don't see, there aren't a lot of tourists going up to like, Utqiagvik, which is formerly known as Barrow. You can't even drive there without having, like a pretty serious SUV and like multiple spare tires and like, spare gas canisters and stuff. So that's so far off the beaten track.
Awesome. Thanks for entertaining these
sure
off the wall questions. You're dispelling the myth of the American citizen who just files lawsuits all the time for frivolous reasons. So let's talk about the world of work in 2020 with so many people working at home or just working remotely. How has that changed the nature of your work this year?
Sure. So in many ways, I work from home now on my personal computer instead of my work computer in an office downtown. But so much of legal work, you can do electronically anyway. The two biggest things that I do in my job are, discovery, which is sort of gathering documents or conducting interviews to try and suss out like what really happened here. And then kind of motion practice and the legal research associated with that. And that's just legal research is all done online on Westlaw since, before I went to law school even. And then, motion practice is just writing. And so you just need Microsoft Word to do that. So I'd say that the two biggest changes have been depositions, which is a form of discovery. It's basically a recorded interview that's sort of done under, threat of perjury. And so, everything you say is like as if you had sworn an oath before the court to tell the truth. And then, then you conduct this legal interview and you get a transcript, which you can then, use as evidence at trial or in a motion for summary judgment or something later. And that was really kind of that. And then court hearings were really although I had court hearings in like Bethel, which is, a 6-hour plane flight, straight west from Anchorage. And so I was conducting those hearings telephonically anyway. But those are really kind of the only two things that you like had to be doing like face to face, or that's much better to be doing face to face. And so we've started conducting like Zoom depositions, which has been, very different. Both because like we don't often use video recording unless you think the witness is just going to come off like really, really badly. And in some way that you'll benefit from that. But usually they're just, audio recordings. And so, but with Zoom, like my face is being recorded as well during the deposition sometimes. And so like I've had to be aware of like the faces I'm making when the other side is asking questions and things like that. And it's also just required a lot more preparation in that, like before I would bring like a box of documents that I might want to enter as evidence during the deposition and attach them to the deposition transcript. And I can't just, but it gave you some flexibility because I'm like, this is the world of documents that I might want to use, but depending on how the deposition was going, I could be like, I had a deposition where I had all these medical records, and I was going to be like, you say this in your complaint, but like your medical records say the opposite. Like, how do you explain that? And then I tried to give him a medical record, and the guy just didn't understand what the hell his doctors were saying to him. Like, he couldn't read his own medical records and make sense of them. And so I realized, like, this is not a strategy that's going to work. And so I just sort of shelved that line of questioning, and it's just like, I'll just use the medical records as evidence, without the deposition testimony. And you can't really do that because you have to give all of the exhibits to the court reporter beforehand so that they can have them ready to bring up on the screen at Zoom, for the Zoom deposition. And so
They don't give you that host control where you can
they do
share your
not.
own
And
screen?
I would never allow my opposing counsel in any of my cases to have that control. And so I could see why. And I assume that they are the same towards me. So it's just required depositions. It's very different conducting an interview over Zoom than in face-to-face, and it's required sort of more. You can't you have to kind of stick to your script more, and it has to be more scripted, which is frustrating because sometimes if you have like a line of questioning that's not working, you're like, well, I can't, skip it now because they've got this evidence. It's gonna screw up their numbering if I don't get to the question that brings up, the exhibit one. And the other biggest change has been that the courts, we're also trying to socially distance as much as possible. And so one of the effects of this is civil cases kind of took the back seat to criminal cases. And so we kind of went through this, it's called a stay, which is effectively pushing like the pause button on litigation. And so most of my cases were stayed, and which meant like we couldn't talk to the court, but we were still talking to each other and conducting discovery. And so that was just kind of sort of like a weird, like, my entire caseload was in like legal sort of limbo for a 2-month period. And that when I was for cases where I had another attorney litigating as opposing counsel, it was not particularly difficult because we all knew what the stay meant and we understood what was going on. But for my 1983 cases where I had, inmates representing themselves, they didn't really understand that. And so I had there was a 2-week period in April when like the case was technically stayed, and the prison inmate filed a new motion every single day for 2 weeks. And then so finally the court was like, the judge sent like a fairly snippy order out reminding this guy that like, hey, this case is on pause while I deal with my criminal docket, and so stop filing stuff until it's done. But then like the effect of that was I still had like 10 motions I had to address, and it gave me like an extra 6 weeks to do it. But so then like all of a sudden I had this huge rush of work at the beginning of the month because all of my cases kind of came back alive June 1st. And so like our office was crazy busy like this last week because we were just, pushing out all these documents that, had to be, oppositions or non-oppositions or just responses to all these like nonsense filings that these prison inmates were making during the stay. And like, so we didn't want to trouble the court. We wanted to keep our credibility with the court by showing that we were good attorneys who were going to listen to what the court told us. But so that led to like, I filed like 10 things on June 1st across like 2 cases. And so,
And then the judge sends out another message. Stop.
Well, I think it's just going to take them a while to get through it all. Right. So we're going to see like, there's going to be there was this huge lag where like we kind of had a bunch of motions building up, and now the courts are finally turning their attention to their civil cases, but it's kind of the dam has burst and they're going to have to start catching back up. And so it's going to.
And I think that's a lot of places in the world. I know that's here in Hong Kong. The courts have just been closed except for emergency cases, and then they've the lower courts have finally opened back up again, and there's it's like the dam has opened. It's just
I've heard like stories of trial court judges here who are like looking at 90 criminal trials for like the first week of October scheduled simultaneously, which is just never going to work, right? And it's just like no jury trials were happening. So the only things that were happening were things that implicated like serious constitutional rights, like, children, terminating parental rights cases, and, sort of criminal indictments, so that we were not going to keep you in prison for, the length of coronavirus while you're waiting to see if you're actually going to be charged with a crime by a grand jury and stuff like that. So those were still going on, but like everything else was pretty much, then criminal issues came first and civil issues came last. And that makes perfect sense because, civil law is really just sort of a financial creature. We're not dealing with people going to prison or anything like that. It's just going to be someone's going to get some money and someone's going to lose some money, and that's all. It's all dollars.
Awesome. Well, you have shared so many experiences and insights. I think we have to send you like $400 fee for this hour. That not quite an hour, but you and I
bill a lot less now that I work for the state government.
Send you some salmon. I guess no, you should send it. You're like, no more salmon. We can send you something from Hong Kong. We can send you some dim sum.
That'd be great.
Yeah. So before we leave, our final question is, what's next? What's next for you, professionally or even just in life?
Sure. Well, in life, I'm in the process of buying a house, so that's the next big change. Professionally, I see myself in my current position for a few more years. And then in terms of what's next, I would either go into the private sector, into some sort of commercial litigation type position, or maybe go work for another judge. I'd be very interested in working at like a federal appellate court, and but there's not a ton of those jobs. There's only like a few hundred appellate federal judges in the United States, and they can only hire 3 law clerks. And so, so that might, be a few years of applications in a row, because they hire like, it's crazy. They hire like 2 years in advance of when you're going to start working for them. And then, so that might be, I might start applying for some, circuit court clerkships and then try and go work for a federal judge at the appellate level instead of at the trial level. So those are probably, but I foresee myself being in this position for a few more years before I make my next move.
Awesome. Well, whenever we can start traveling again, going from Asia back to the United States, we often fly over Alaska the way the plane routes go. So if you're still there, I'll hop out of the plane as we're going over Anchorage. I'll stop in for a beer or something. Yeah,
you should. Anchorage has, I was sort of surprised. Like I've been brewing beer for, like 7 years now. And, in California, there's just such like a vibrant microbrewery scene. And I was really worried about moving to Alaska, but it's actually pretty solid. I think there's just so much tourism here that like actually the food and, alcohol industries are a lot of a bigger presence than like the population of Anchorage would indicate, because we have so many tourists coming in the summer. So that was a pleasant surprise. So we got really good beer in Alaska, better than I thought I would get.
Awesome. Well, thank you so much for your time, for the insights, and I look forward maybe to seeing you. And if anybody has questions, if they put them in the comments, I can relay them back to you. Sure. We don't get a lot of questions, but you never know. Someone might be interested. So.
Sure, I'm happy to I'll try and if you give me the link on YouTube, I'll try and monitor for comments as well.
Sounds great. I'll keep you posted. Thanks so much, Chris.
Thank you.
Cheers.
Bye-bye.